The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Our first order of business is to ratify an updated subcommittee roster. Every member should have a copy on his or her desk. I ask unanimous consent that the committee approve the appointments and assignments for our subcommittees as shown on the roster. And without objection, the roster is approved. Pursuant to notice, I now call up H.R. 2851 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2851, to amend the Controlled Substances Act to clarify how controlled substance analogs are to be regulated and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. According to the National Institute on Drug Abuse, a component of the Department of Health and Human Services, about 19,000 Americans died from drug overdoses in 2001. That is approximately 52 a day. However, the frightening reality is that figure skyrocketed to over 52,000 deaths in 2015, or about 144 people per day. And preliminary data indicates at least 59,000 drug overdose deaths occurred in 2016. Put another way, that is a more than 13% increase in overdose deaths in 1 year. Nearly 1/5 of the deaths in 2015 resulted from an overdose of synthetic opioids like fentanyl. H.R. 2851 is designed to stop this trend. The dangerous synthetic drugs that are the focus of this bill have no legitimate industrial or medical use, and the terrifying numbers I just mentioned show their abuse constitutes an ongoing public health and safety epidemic in the United States. Most of these synthetic substances properly belong in Schedule I with the most dangerous drugs. However, the Controlled Substances Act was not designed to tackle the flood of over 400 known synthetic analogs with which we are presently confronted. To make matters worse, there are thousands of variations that criminals can make in their foreign laboratories simply by altering a single molecule in the substance. Over the past several years, members of Congress and this committee have debated whether to wait roughly 3 years for the executive branch to control a substance, or for us to act and legislatively place a laundry list of substances in Schedule I. But either way, there are no good options in current law for rapid action to protect the American people. However, what is certain is we can no longer afford to wait 3 years for a substance to be controlled. Americans are overdosing and dying in record numbers. Nor can we depend on the legislative process to address this issue. As with so many other things, the criminals are much more nimble than law enforcement. H.R. 2851, which is the subject of years of work, will ensure that we are no longer limited by only 2 bad options for combating dangerous synthetics. This legislation provides a rigorous and timely process to get these drugs out of the hands of criminals who exploit human misery for profit and put them into the hands of qualified researchers. This bill's bipartisan and bicameral approach is highlighted in its reasonable and balanced methods towards stemming the manufacture and importation of dangerous drugs while ensuring synthetic drugs can be researched by qualified individuals and institutions. Nearly all of the synthetic substances are made in China and Mexico for distribution in the United States. Even though most of these drugs have the properties of the most potent drugs in Schedules I and II, this bill sets the equivalent of Schedule III penalties for trafficking and distribution. This means that these substances are generally not subject to mandatory minimum sentences for trafficking and distribution. The bill also does not criminalize simple possession of the substances. There must always be a multi-pronged approach to combating drug abuse, with enforcement, treatment, and education being some of the key components. Last year, Congress passed the Comprehensive Addiction and Recovery Act on a nearly unanimous basis. Today, before this committee, there is an opportunity to apply existing laws to a class of drugs which have evaded law enforcement and wreaked untold havoc on our constituents, due to the resourcefulness of criminals who exploit a legal loophole, who manufacture, import, and traffic these deadly drugs solely for profit to prey upon human misery. This loophole must be closed. Supporters of this legislation include the National Fraternal Order of Police, the National District Attorneys Association, the American College of Emergency Physicians, and the National Kratom Coalition. Without objection, letters of support from these organizations will be made a part of the record. I want to thank Mr. Katko and Ms. Rice, both of New York, for their work on this legislation, this bipartisan, bicameral legislation, and I urge my colleagues to support it. And it's now my pleasure to recognize the ranking member of the Judiciary Committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, this measure before us is intended to address the problem of illicit use of analog synthetic drugs. This bill involves important issues concerning public health and safety and also fairness in our criminal justice system. I appreciate the desire of many to protect our citizens from dangerous drugs, but this measure deserves much more careful examination. I recognize that analogs to some synthetic drugs are dangerous and are harming our citizens, especially young people. Some of these modified man-made substances are even more potent, more dangerous, and oftentimes more deadly than the substances that they are designed to mimic. However, in addressing these drugs, the dangers these drugs pose, I believe the Congress must be careful in advancing any legislative response. Unfortunately, H.R. 2851, although I am willing to concede is well-intended, it is ultimately unwise for several important reasons. To begin with, this measure would give the Attorney General almost unfettered authority over the regulation of these substances. While much of the conversation surrounding synthetic analogs focuses on the chemistry of the substances, from the process of manufacturing them to their effect on the human body, H.R. 2851 would eliminate vital scientific and medical evaluations normally undertaken by the Department of Health and Human Services and the Food and Drug Administration, and do away with binding recommendations provided by the Department of Health and Human Services in scheduling drugs. There are already statutory mechanisms in place to provide for the scheduling and regulation of new drugs that may be dangerous if misused. Those mechanisms require an appropriate degree of collaboration among the Justice Department, the Department of Health and Human Services, and the Food and Drug Administration in scheduling synthetic analogs. This is because each of these agencies are equally important to the scheduling process. And under this bill, not only would the Attorney General hold the sole authority to schedule these substances, but he or she would also have the power to shape sentencing policy without the input of the United States Sentencing Commission that is currently studying the issue of synthetic drugs and penalties. We must be cautious in our response to synthetic drugs and heed the lessons we learned from the fear-driven legislation enacted in response to crack. For example, H.R. 2851 would establish lengthy and sometimes mandatory minimum penalties for certain offenses involving these analog drugs. We all know some of the problems that we've discovered dealing with mandatory minimums. Now, while mandatory minimum sentences give the appearance that we're taking strong action to address the problem, they are patently unjust as a matter of sentencing policy and are unnecessary to the imposition of appropriate sentences. That is the job of the Judiciary Committee. Indeed, extremely lengthy sentences are sometimes appropriately imposed by judges, but over-penalization through mandatory minimums is counterproductive and only contributes to our crisis of over-incarceration. Also, this bill has the potential to chill medical research into substances that may be beneficial or into alternative treatments for drug addiction itself. We must be careful not to harm innovation and exploration into the development of new drugs that can actually help us. And so in closing, I want to note that the committee has received a letter from more than 65, repeat, 65 advocacy organizations opposing this bill, including among them the American Civil Liberties Union, the Leadership Conference on Civil and Human Rights, and Families Against Mandatory Minimums. And furthermore, we just received a letter yesterday from a number of conservative groups opposing the bill as well. The signatories included Freedom Works, the American Conservative Union Foundation, and the Taxpayers Protection Alliance. Please, we must not ignore their concerns as we consider approaching this issue through legislation. And so it's regretfully that I must oppose this bill and ask my colleagues from both sides of the aisle to examine it with extreme care. I thank the chairman, and I yield back the balance of my time.
Chair thanks the gentleman and now recognizes himself for purposes of offering an amendment in the nature of a substitute.
Mr. Chairman, I'd like to strike the last word.
You want to? We'll recognize you as the ranking member of the subcommittee. Gentlewoman from Texas recognized for her opening statement.
I thank the gentleman very much. I thank the chairman of the subcommittee on crime for his thoughtfulness and congratulate him on his chairing that committee in this session, and acknowledge the very thoughtful statement of my ranking member on the obvious and conspicuous support and recognition of the dangers of synthetic drugs and the death that is being created in our districts and throughout the nation. And frankly, I have said in other places that it is our task to ensure that we do things for the American people. It is important to take note that in the criminal justice bill that we discussed in the last session, we included an enhanced sentencing, not a mandatory minimum, for fentanyl. We recognized this a long time ago. But this bill creates a new schedule of the Controlled Substance Act, Schedule A, which will allow the Attorney General to take new unprecedented powers to add to this schedule any drugs he perceives to have the same or similar effect as opioids currently on Schedule 1. No scientific basis, no PhD, just the Attorney General, who was in fact all throughout the efforts that we engaged in to have criminal justice reform was a major obstacle and continues to be a major obstacle in any form of criminal justice reform. This bill also imposes harsh penalties for drugs placed on Schedule A, absent any verifiable scientific research, as currently required by law. There lies the heavy hand of the Attorney General, and from the harms caused, it is also the case that we all want to protect our citizens, our streets, and our communities from the harm caused by these drugs, but we are again putting mass incarceration as our chief effort. And we know that the hearing that we heard from the chief chemist of Pinellas County Forensic Laboratory. We learned about the process of analyzing chemical compounds. It is not an easy task. And so mandatory sentences are absolutely at the heart of this bill, even though it's represented that it is not. The scope of the AG's authority is both broad and dangerously unchecked, and it allows the Attorney General to put into motion his failed war on drugs that so many have acknowledged simply does not work. I would make the argument that we are supported in this, not by all of our wonderful liberal friends or leaders that understand that they're liberal, but they work for the American people, the Leadership Conference on Civil and Human Rights, and the Judicial Conference that argues vigorously against this particular legislation. But we have our friends from the Freedom Works, American Conservative Union, Generation Opportunity, Taxpayers Protection Alliance, and they are shocked because they say in recent past, this committee seemed to be making progress toward an improved federal criminal justice system. In our Bipartisan Citizen Reform Act of 2015, now we seem to be retrogressing and going into the past failed opportunities. And so I find it very difficult to see this bill as a step forward. But let me also say that I have made a commitment to be honest to myself and the American people, Mr. Chairman, and frankly, I am baffled that we have yet to open an investigation into the actions of the Trump administration and to do our due diligence and oversight over the Department of Justice, either through the firing of Director Comey. But I was amazed to see the coolness and the anger expressed by Mr. Trump Jr., and let me say that all parents defend their children, and I respect the President's defense of his son. But it is clear that the violation of a number of ethical rules, the idea of soliciting information by a foreign entity adverse to the United States interests by going to a meeting that you were solicited to come to get bad information about Hillary Clinton, the fact that the meeting occurred, leadership of that campaign was there, and for those of us who run our races, we know that it's impossible for our campaign leadership to go to any meeting and not come back and give us a summary of what occurred. We are overdue for responding to the American people, not as Republicans, not as Democrats, Mr. Chairman, but as American leaders that owe a debt of responsibility to the Constitution and to the laws of this land. I hope Mr. Ryan will hear me loudly and clearly and unleash and release this committee to open its investigation. And with that, Mr. Chairman, I yield back. Thank you for your courtesy.
Time of the gentleman has expired. I now recognize myself for purposes of offering an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2851 offered by Mr. Goodlatte. Strike all that follows after the...
Without objection, the amendment is considered as read, and I'll recognize myself to explain the amendment. Two weeks ago, the Crime Subcommittee held a legislative hearing on H.R. 2851. At that hearing, I and my colleagues listened closely to the testimony, particularly the comments of the research community. Though I have been and will continue to be committed to stemming the tide of illegal drugs into this country, I have also consistently supported strong and vigorous research into controlled substances by qualified individuals and institutions. As a result, this substitute amendment has rewritten and enhanced the research exemptions in H.R. 2851 to allow competent, qualified researchers timely access to Schedule A substances while preventing drug diversion. This amendment will add a new subsection to the federal statute governing registration to provide an exemption for researchers of Schedule A substances. My amendment directs the DEA to register researchers, whether individuals or institutions, in a timely fashion. Significantly, if the researcher already maintains a Schedule I registration, the amendment states that the applicant is qualified to conduct research on Schedule A substances and directs DEA to modify the applicant's registration accordingly. In this way, the amendment ensures that research into the substances that will be placed on Schedule A can continue with little to no interruption or interference. To ensure this is all done in a timely fashion, my amendment requires the DEA to act upon an application for a Schedule A registration within 30 days of receiving the application. In the 21st century, it is vital that scientific research continue to serve humankind, to cure diseases, promote scientific discovery, and otherwise improve people's lives. This amendment serves that goal by striking an appropriate balance between the need to combat drug trafficking and the need to promote research, and I urge my colleagues to support this substitute amendment. Does the gentleman from Michigan wish to be heard on the substitute?
Not at this point.
Chairman.
May I just say, Chairman Goodlatte, that this is an improvement. And the problem, though, is that I oppose the amendment on the basis of some of the concerns I've raised, and you have moved a step, maybe several, toward making it more accommodating to many of us. I hope we can find a way to address the problem of analog drugs without adopting legislation that will frankly do more harm than good, and I thank you for this opportunity.
I
Chairman.
thank the gentleman. What person, the gentleman from Wisconsin, seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2851 offered by Mr. Sensenbrenner. Page 6.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, I think I have the answer to most of the concerns that have been raised by the gentleman from Michigan and the gentlewoman from Texas. What this amendment does is, number one, get rid of the mandatory minimum penalty. You know, I served with many of my colleagues on the overcriminalization task force. I agree with them that we've gone too far on overcriminalization, and while I'm not for a blanket abolition of mandatory minimums, this is the type of legislation that should not have a mandatory minimum attached to it. Secondly, what the amendment does is it gets Congress in on the act so that the Attorney General and the DOJ, do not have, an exclusive authority over scheduling or not scheduling the new types of synthetic drugs. And the first part of the amendment gives Congress a 180-day window in which to disapprove of the scheduling of a new drug as the Attorney General has asked for. And there's been some talk about whether we ought to have affirmative approval or disapproval. I think the disapproval method, which is somewhat similar to what we already have in law on drugs and also on other things, is probably the way to go as of now. And then we can debate whether to have affirmative approval of rules, not just in this area, but at everything else at a later point of time. So I think this amendment addresses the concerns that I have heard from people on the other side of the aisle, and I would urge support of the amendment. And if the amendment is adopted, I think that most of the objections to this bill would be eliminated. I yield back.
Chair thanks the gentleman.
Mr.
First
Chairman,
gentleman from Michigan, seek recognition.
strike the requisite number of words.
The gentleman is recognized for 5 minutes.
I am in a curious position in that I do not object to this amendment, which I believe makes one important change, but also one that will not address other serious concerns with the bill. First, I welcome the portion of the amendment which would remove the mandatory minimum sentences from the bill. Judges are in the best position to impose sentences because they're aware of all the relevant facts and circumstances bearing on the culpability and appropriate sentences in each case. Our task in this committee of the judiciary should be to remove mandatory minimums from the code, not to impose new ones or expand existing ones. Therefore, supporting removing mandatory minimums from this bill, I think, is extremely important. In this regard, I commend my colleague from Wisconsin, Mr. Sensenbrenner, for his stand against these mandatory minimums, and I look forward to making more progress on this issue. The other main provision of this amendment would establish a mechanism for Congress to disapprove the temporary addition of analog drugs to the new Schedule A within 180 days of their proposed addition by the Attorney General. I do not find this to be an adequate means of addressing concerns about the fundamentally flawed mechanism this bill would establish for adding new drugs on a temporary or permanent basis to a schedule that subjects individuals to criminal penalties. The burden should be on the government to get it right in the first place, employing a sound and thorough processing requiring deference to the scientific and medical judgment of the Department of Human Services and the Food and Drug Administration. I do not oppose adding this mechanism for disapproval, but it does not address the flawed process in the bill. Although I will support the adoption of this amendment because of the removal of the mandatory minimum sentences, I must continue my opposition to the larger bill because of my other concerns. I thank the chair and I yield back the balance of my time.
Mr. Chairman.
What purpose does the gentleman from Texas seek recognition?
I rise to discuss the gentleman's amendment and
Gentleman is recognized for 5 minutes.
strike the last word. I had had discussions with Mr. Sensenbrenner's office and thought this was a bipartisan amendment with my support, but I rise to indicate, as has the ranking member, my appreciation for this amendment and the elimination in the amendment of the mandatory minimums. As I indicated in my opening statement, the letters from our friends on the conservative side of the aisle have taken a negative look at this legislation. I don't think any of them could be called to be as representatives of individuals who are not aware of the opioid epidemic. Their letter says the United States opioid epidemic is real and overdoses are increasing year after year. But H.R. 2851 will do nothing to fix this. Harsh penalties do not deter people with substance use disorders from using drugs. People use drugs because they have a chemical dependence and often feel they will not be caught. Believing that harsh penalties will deter drug use misunderstands addiction, and it falls into the trap of Attorney General Sessions, who wants to roll back all recognized criminal justice reforms that have been proven to work over the last decade. And so I want to thank the gentleman for his amendment. I intend to vote for the amendment because I believe that any acknowledgement of the unfairness and the inappropriate use of mandatory minimums is worthy of support. I do think the resolution of disapproval, having been in Congress, certainly not the years that the gentleman from Wisconsin has been, is a very difficult tool to use, but I do appreciate the utilization of that tool to acknowledge that Congress would have a role in its wisdom, hoping that Congress believes that the reform of the criminal justice system and the elimination of mandatory minimums is the right approach, and the relying upon the Attorney General with no scientific research experience except for the allowing of the registered researchers to now participate in Schedule A. That's going to be very difficult. But I join with my friends from the conservative community that says that they believe that this legislation, the underlying legislation, is gross federal overreach. Congress, our elected legislature charged with passing laws and creating the federal criminal code, should not devolve the power to enact new criminal punishment to a federal agency. This is not Sheila Jackson Lee, and this is not our wonderful advocates. It is the group that I just mentioned, Freedom Works, American Conservative Union Foundation, Generation Opportunity, Taxpayers Protection Alliance. And that is my main underlying assessment of where we are. But the gentleman's amendment and the gentleman himself should be commended because I think this is a recognition of the testimony that we heard at the hearing, and it is also a recognition that it is inappropriate to now trust the Attorney General of the United States with the whimsical decision and responsibilities of eeny, meeny, miny, mo, putting these drugs in that category. We want to save lives. Synthetic drugs are killing. We have to get our hands around the users and the sellers, and I believe we have the laws that can do so. If we focus on the consumer market, addicted persons with treatment, care, and intervention, and we shut down this market, we can begin to turn people's lives around, and we can begin to do a much better job, as we have tried to do with the opioid bill that came out of this particular committee in the last session of Congress, and that I hope that we'll have the opportunity to be able to work on together. So I thank the gentleman from Wisconsin for his amendment, and I look forward to supporting his amendment. I yield back.
Question occurs on the amendment offered by the gentleman from Wisconsin.
Sorry, Mr. Cohen.
First, the gentleman from Tennessee, seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I understand the difficulty of synthetic drugs and changing one molecule and making it difficult, and that's a problem we need to deal with, and this might be the best way to deal with it. But you have to consider what you're dealing with. We're dealing with an Attorney General who has said that good people do not use marijuana. I don't know what he means by good people, but I know that over 60% of people polled think that marijuana should be legalized. That doesn't necessarily mean they smoke marijuana, but they think it should be legalized. There are a lot of people who have smoked marijuana and admitted they've smoked marijuana or been arrested for smoking marijuana who are good people. In fact, polls that I have seen say that it's mostly Trump voters who favor legalizing marijuana because they use it and because they think it is a wrongful government deprivation of liberty of individuals doing a drug that they choose to do, and that they should have that right. Attorney General Sessions seems to be caught in the 1930s in the Harry Anslinger mode thinking that marijuana is a gateway drug and evil, and that people who smoke marijuana are not good people and should be arrested. If we are talking about rescheduling, Mr. Chairman, I see I don't have the chairman's ear, and that's okay. I understand that because I don't think I'd have had his mind either. The fact is, what we should be doing is rescheduling marijuana. To have marijuana scheduled Schedule 1 with heroin and ecstasy, Mr. Chairman, and acid is ludicrous. It is ludicrous. And so, Mr. Chairman, we're not getting the ear or the brain. This is a wonderful approach on synthetic drugs, but you're missing the issue. The issue that the American people want to see us address is the insane policy of Schedule 1 being the schedule for marijuana. And we've got like 28 or 29 states that have legalized it for medical use in the District of Columbia, and I think it's 5 states in D.C. where it's legal for quote-unquote recreational. Now, I don't know what recreational is. It may be even 8 states that have legalized it for recreational. All 50 states have recreational alcohol, but only 8 have recreational marijuana. We should find a way through this bill to say that marijuana should not be Schedule 1, because we need not only freedom and liberty and sanity, but we need research. And so it's great to let people, Mr. Chairman, have the opportunity to research synthetic drugs, but what they need to be researching is marijuana to see if those 28 or 29 states that let people use it for...
Would the gentleman yield?
Yes, sir.
I'd be happy to work with the gentleman on such a law, but it's not a part of this bill because marijuana is not synthetic. But
no, it's not synthetic indeed, but this does give the Attorney General powers, and in bringing such a bill to give the Attorney General powers concerning scheduling...
You were talking about changing the law to make it easier to do research
right.
on cannabis.
Yes.
To find therapeutic benefits from some of the chemicals contained in it, and I am interested in working with the gentleman to accomplish that goal.
Well, thank you, sir. That's good news, and I appreciate it. I look forward to working with you on it. But as I reiterate again, polls show it's Trump voters who are most encouraged and wanting to change this law. And I look forward to making those Trump voters happy and safe in their homes and in their choice of recreational products.
Will the gentleman yield?
I yield.
I've just been brought, I'm going to blame my able staff, but it's been brought to my attention that the individual that we want to give all this power, General Sessions, is on record as saying that he thought the KKK was okay until he heard that they smoked marijuana. So that's certainly extreme, and I would hope that we would consider what impact this bill is going to have on innocent persons who are just trying to get well again. I yield back.
Thank you. Well, at least that's something else marijuana has done good, is convince General Sessions that the KKK was bad.
I don't know if he did. Did he?
Question occurs on the amendment offered by the gentleman from Wisconsin. No, your amendment has not been adopted. Question occurs on the amendment offered by the gentleman from Wisconsin. All those in favor respond by saying aye.
Aye.
Those opposed? The ayes have it, and the amendment is agreed to. Are there further amendments to the amendment in the nature of substitute?
Mr. Chairman,
What puts the gentleman from Florida seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2851 offered by Mr. Gates of Florida. Page 8, line 15.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman, and I'd like to begin by associating myself with the comments of the gentleman from Tennessee and to also confess that I am one of the Trump voters who believes that it is absolutely insane that marijuana is a Schedule I drug, that we're not unlocking cures and the potential to improve people's quality of life. And it seems ludicrous to me that any notion of conservative limited government would put the federal government between someone who is ailing, in pain, and something that could potentially help them. And so I appreciate the gentleman's comments. There was a young girl I met in 2013 in my district. Her name's Ray Ann. She was having dozens of seizures every week. And she had learned that in Colorado there were children with refractory epilepsy who were seeing therapeutic benefit as the consequence of non-euphoric medical cannabis use. And so she came to me as her state representative and as chairman of the Criminal Justice Committee in the Florida House of Representatives, and their family lobbied me to try to bring some common sense solutions that could save this girl's life. I'm very proud that I was able to sponsor and pass legislation that made non-euphoric medical cannabis available to constituents like Rayanne. Unfortunately, when I went to the University of Florida to see if they would do research on medical cannabis, would they accept grants from the state of Florida to learn what therapeutic options might be available, the University of Florida said to me that they couldn't do so. They couldn't do research, that it would impair potentially over $100 million in federal grants as a consequence of an idiotic federal law that reinforces dogmas that suggest that there can be no medical value to cannabis. And so, Mr. Chairman, in this legislation, there in fact is a provision that indicates who we will not prosecute. It's on page 8. It begins at line 12 and goes to line 15. And so while we're in the business in this legislation of saying who we don't want to throw in jail, I thought it would only seem reasonable to say that we wouldn't throw people in jail for researching any substance which at least half of the states in the United States of America have legalized for medical use. Now, I can't imagine any adult, much less any elected member of Congress, believing that it is a good idea that people are medically using something in 25 states that we, the federal government, won't allow research for. Or we make the process for research so cumbersome that it is functionally impossible. And so I am fulfilling my commitment to a little girl that was having dozens of seizures a day, to a girl who could barely talk but who's now on a softball team, who thought that life might end during her teen years and now fills her home with laughter and hugs. I'm fulfilling my commitment to her to fight for research and to fight to unlock cures and potential. This should not be a partisan issue. Republicans and Democrats should be willing to come together despite disagreements on our overall positions on cannabis and at least have the maturity to be able to stand up and say, let's have the brightest people in this great country. Let's have the most skilled professors, the most innovative researchers, the most forward-looking companies at least have the opportunity to see what potential is available. Across the world today, there is research being done on medical cannabis. But unfortunately, due to the arcane and I would suggest indefensible laws that we maintain in the federal government, that research is occurring in the UK, in Israel, in Germany, all over the world, but not here. We should be ashamed of that. But I am so grateful. I'll conclude with my sense of hope that our wonderful Judiciary Chairman has indicated to the gentleman from Tennessee that he too would like to see us make progress on this issue. He too cannot defend this concept that we don't want to research something that people are legally using under state law in half the states in the country. And so I'm grateful for the chairman's leadership on the issue. I look forward to working with him, and I yield to the gentleman from Tennessee.
Thank you very much. First of all, I wish I'd have worn my hat today because I would take it off to you. It is refreshing and commendable to hear the chairman and you speak about the opportunities we have for research on marijuana and helping people through life. We're only here for a short period of time. And if there's something out there that can help people get through illness, through discomfort, through life, that helps them, we should help that process along and not incarcerate and not deter. Let me tell you a little story. I've had on more than several occasions, I've had people come up to me, Republicans, and they say, you know something, I don't agree with a lot of what you do. This is when I was a state senator and a congressman. But I always vote for you because of your position on puppies and kittens and marijuana. That wins. Thank you, and I yield back the balance of my time.
Without objection, the gentleman is recognized for an additional 30 seconds if he would yield to me. The same commitment that I made to the gentleman from Tennessee, I certainly would make to the gentleman from Florida, and if he would withdraw the amendment, I'd be happy to work with him on the issue of research into therapeutic benefits from the cannabis plant.
I thank the chairman. I share the gentleman from Tennessee's support for puppies and kittens, and I withdraw my amendment at this time.
Chair, thanks, gentlemen. Are there further amendments to H.R. 2851? For purpose of the gentleman from Texas seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2851 offered by Ms. Jackson Lee. Add at the end of the bill
Without
the
objection, the
following.
amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
I thank the chairman. This amendment wants to ensure that we have the information as legislators to understand the impact on the fiscal note on this bill, asking that the Comptroller General of the United States complete a study and submit a report to the Senate and House Judiciary Committees to deal with the annual amounts expended by federal agencies in carrying out these amendments, the costs associated with the arrest, trial, convictions, imprisonment, or imposition of other sanctions in accordance with the amendments, and the impact, including the fiscal impact of the amendments on existing correctional facilities and the likelihood that those amendments will create a need for additional capacity. I don't think I need to further explain the infusion of newly declared criminals that will come about through this legislation. Again, we have indicated that we have no quarrel with the massive impact of opioids, and we want to see them extinguished, stopped, and we want to see lives saved. But we recognize that this bill will have an alarming impact as mandatory sentences, including mandatory minimum terms of supervised release, will take up valuable taxpayer dollars, create an injustice in sentencing, and undermine guideline sentencing. The aspect of the inclusion of supervising an offender that comes about through this legislation is extremely important. And conservative groups agree that taxpayers will be forced to pay an increased amount for a population of these individuals. We've eliminated mandatory minimums, but we haven't eliminated the fact that they may go to jail. And so I would hope that we would join in wanting to get the fiscal note, and I ask my colleagues to support the Jackson Lee amendment.
Would the gentleman yield?
I'd be happy to yield to the gentleman.
I'm going to respond favorably to your request and support the Jackson Lee amendment, and I urge my colleagues to do the same. I think it's a good amendment.
I thank the gentleman, and with that, I happily yield back, and I thank the chair and the ranking member. Thank you.
Question occurs on the amendment offered. What purpose the gentleman from Michigan seek recognition?
Only to support the Jackson Lee amendment, as you have.
Chair thanks the gentleman. The question is on the amendment offered by the gentleman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the amendment is agreed to. Are there further amendments to H.R. 2851? For purpose the gentlewoman from California seek recognition.
I have an amendment at the desk.
Clerk will report the amendment. We do not have that amendment.
Why not?
That I can't answer.
What, I think Ms. Jayapal has an amendment, or Mr.
apparently the-
Cicilline. Why don't I find out what's, oh, here are the copies now.
Here it comes.
Can I have
Clerk will report the amendment.
amendment to the amendment in the nature of a substitute to H.R. 2851 offered by Ms. Lofgren of California.
Mr. Chairman?
What purpose the gentleman from Wisconsin seek recognition?
Chairman, I reserve a point of order.
Point of order is reserved. Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. This amendment would direct the Attorney General to remove marijuana from Schedule I of the Controlled Substances Act. The current Schedule I classification of marijuana puts it, as has been previously discussed, with heroin, ecstasy, LSD, peyote, quaaludes as a drug with, quote, no currently accepted medical use and a high potential for abuse. Now, as has been discussed earlier, and there are different ways to remedy this, the classification of marijuana in Schedule I does limit the access of researchers to the substance so that its medical application can be studied. We do know, and our colleague from the other side of the aisle has mentioned the utility of non-psychoactive marijuana for certain children who are suffering from epileptic seizures. We have anecdotal advice, and I remember very well personally someone I knew who's now passed away who was suffering from cancer, who before the voters of California legalized marijuana, would have to go down and buy marijuana from kids on the street so that he could actually eat and keep food down while he was undergoing treatment for his cancer. There may be more potential medical applications, but we're not going to find them. I would note also that voters in the state of California made a decision. First, they voted to approve the use of marijuana for medicinal purposes, and then just this last year, they voted to decriminalize marijuana. I think the idea that citizens of California who are complying with the state law would nevertheless be subject to federal prosecution is very troubling. The fact that this is on Schedule I creates other problems. Right now, you have a legal marijuana business in California, but it all has to be done in cash because there's no access to the banking system because of the Schedule I designation. And so you have the potential for corruption because of all the cash. You've got a potential theft problem because of all the cash. And certainly the state of California wants to tax this business. And since it has to be an all-cash business, that becomes more problematic. So I offer this amendment in the hopes that it would solve a whole set of problems: the research problem, the problem of states like my own where voters have chosen to legalize use of this substance, the crime problem created by lack of access to the banking system. And I think that this is the least we should do, Mr. Chairman, in terms of respecting the voters of the state of California.
Will the gentlelady yield?
I would be happy to yield.
I thank the gentlelady for yielding. I would point out that I've sponsored H.R. 2020, which does precisely what this amendment does, and I would invite the gentlelady to join me and help us with that bipartisan legislation.
I will take a look at that bill. I was not aware of that, and perhaps we'll get your support on this amendment.
I yield you back. I yield back.
And I yield back, Mr. Chairman.
Does the gentleman from Wisconsin insist upon his point of order?
I do.
Gentleman is recognized.
Mr. Chairman, I make a point of order that the amendment is not germane. It deals with another subject. The underlying bill, deals with Schedule A. This talks about Schedule I. It creates a new schedule. I regret that a bill relating to synthetic drugs, the debate has degenerated into a talk about marijuana. We should be talking about marijuana separately and not getting the marijuana debate into dealing with these very strong and powerful synthetic drugs like fentanyl, and more of them are on the way. So I would urge the gentleman, the chairman, to sustain my point of order because it isn't germane.
Does the gentlewoman offering the amendment wish to be heard on the point of order?
Well, Mr. Chairman, I suspect that your ruling is going to be along the lines outlined by our friend Mr. Sensenbrenner. I thought this was germane because it dealt with the general subject, but if as a technical matter it is not, I certainly would accept that ruling. My friend from Tennessee may have an additional point on the germaneness issue.
Well, my only question is what Mr. Sensenbrenner said, which I agree with, that we're dealing with potent and strong and dangerous drugs, but are not scheduled as high as in the same category as marijuana. They're scheduled as less powerful and less serious, and that shows the inconsistency and the anachronicity of this particular section of the code. This is an anachronistic place. And it never was marijuana, never should have been there.
The gentleman needs to restrict his comments to the issue of germaneness.
I'll yield back.
Reclaiming my time, we are dealing with the same section of the code that this would amend.
The chair is prepared to rule on the point of order. In the opinion of the chair, the amendment is not germane. Are there any other amendments? If not, the question is on the amendment in the nature of a substitute. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. Are there? The question now occurs, a reporting quorum being present, question occurs on H.R. 2851 as amended. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it. And the bill as amended is ordered reported favorably to the House.
Mr. Chairman, I think there were two amendments. I'm sorry, we didn't realize you were already doing a vote. I have an amendment, as does Ms. Jayabal.
I think we've already adopted the substitute. I don't think they can be offered. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute.
Chairman, may I have a parliamentary inquiry?
For gentlewoman of state or parliamentary inquiry.
Mr. Chairman, as chairman of the full committee, do you have the opportunity to waive the present status of having cast and carried a vote to allow two amendments in?
I'm sorry.
Do you have had the substitute amendments have been submitted?
Substitute has been adopted, and I did call for further amendments. I did not hear from either of the.
And so the only question I have is, do you have the opportunity or to waive that particular procedure?
I do not have the opportunity to waive, but I'll be happy to confer with both the gentleman from Rhode Island and the gentlewoman from Washington as to what the nature of their amendments, and if we can in some way incorporate them moving forward, we'll be happy to consider that. But the substitute has been ordered. In fact, the bill has now been passed. And members will have 2 days to submit views without objection. No, the time for the recorded vote has passed as well. Without objection, the bill reported as a single amendment in the nature of substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. And I'll be happy to meet with the gentleman from Rhode Island and the gentlewoman from Washington and consider what their concerns were, but we did call for additional amendments, and they did not respond at that point. At this point, pursuant to notice, I now call up H.R. 469 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 469, to impose certain limitations on consent decrees and settlement agreements by agencies that require the agencies to take regulatory action in accordance with the terms thereof and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. The untimely drag of new regulations, too often issued without sufficient consideration of their costs, benefits, and impacts on jobs, held back economic recovery throughout the Obama years. Although the Trump administration is delivering regulatory relief, without the help of statutory reform, relief may only be temporary, not permanent. The Sunshine for Regulatory Decrees and Settlements Act of 2017 is an important part of this needed statutory reform. Far too often, costly new regulations are issued directly under the authority of consent decrees and settlement agreements that force federal agencies to issue new rules. These decrees and settlements typically stem from deals between regulatory agencies and pro-regulatory plaintiffs. Those to be regulated, our nation's job creators, frequently do not know about these deals until the plaintiff's complaints and the proposed decrees or settlements are filed in court. By then, it is too late. Regulated businesses, state regulators, and other interested entities are unlikely to be able to intervene in the litigation. The court can approve the deals before regulated parties even have an opportunity to determine whether new regulatory costs will be imposed on them. The Obama administration entered into a high number of consent decrees and settlement agreements like this. Prominent examples include decrees and agreements that require the Environmental Protection Agency to issue Clean Air Act maximum achievable control technology standards and Chesapeake Bay TMDLs that triggered billions of dollars in costs. The Sunshine for Regulatory Consent Decrees and Settlements Act of 2017 puts an end to the abuse of this practice. It assures that those to be regulated have a fair opportunity to participate in the resolution of litigation that affects them. It ensures that courts have all the information they need before they approve proposed decrees and settlements, and it provides needed transparency on the ways agencies conduct their business. At the same time, the bill also respects the basic rights of plaintiffs and defendants to manage litigation between them. As a result, this legislation offers an effective and balanced remedy. This bill is a timely solution to a real and important problem. I thank Representative Collins for his reintroduction and continued championship of this legislation. I urge my colleagues to support the bill and yield back the balance of my time. The gentleman from Michigan is recognized.
Mr. Chairman, I rise with some reservations about H.R. 469, because after looking it over, I've come to the simple conclusion that its purpose is to discourage the use of settlement agreements and consent decrees. Its simple goal is to discourage the use of settlement agreements and consent decrees. This bill, by delaying regulatory protections, jeopardizes public health and safety. This explains why the administration issued a veto threat against a very similar version included in legislation considered in the last Congress. It also explains why a broad consortium of more than 150 organizations strenuously oppose this bill. These organizations include the National Resources Defense Council, the American Civil Liberties Union, the NAACP, the Sierra Club, and Earth Justice. More than 150 organizations strenuously oppose this bill. Simply put, this bill could be used to prevent critical, life-saving federal regulatory actions from being implemented. The bill gives opponents of regulation multiple opportunities to stifle agency regulatory actions by allowing essentially any third party who is affected by such actions to intervene subject to rebuttal, participate in settlement negotiations, and submit comments of a public nature about a proposed consent decree or settlement agreement that agencies would then be required to respond to. Now, in the case of consent decrees concerning a rulemaking, an agency would be forced to go through 2 public comment periods, one consent decree and one for rulemaking that results from the consent decree, doubling the agency's effort. Take, for example, a consent decree resolving a dispute under the Clean Air Act. The bill would allow any private party whose rights are affected by such a decree a right to intervene, which could conceivably include anyone who breathes air. Like nearly all of the anti-regulatory bills we've considered to date, over the last 3 Congresses, H.R. 469 piles on unnecessary procedural requirements for agencies and courts. Another concern is that the bill threatens to undermine a critical tool, that Americans use to guarantee their congressionally mandated protections, including civil rights laws. By reducing costly and time-consuming litigation, consent decrees and settlement agreements benefit both plaintiffs and defendants. They ensure that the federal protections are enforced while giving state and local governments flexibility as to how to meet their federal obligations. Consent decrees in particular have been instrumental in enforcing various civil rights laws in a wide variety of cases, ranging from those involving voting rights to reform of mental health institutions to law enforcement misconduct. Indeed, they are at the heart of civil rights enforcement. Because of H.R. 469, a chilling effect on the use of consent decrees and settlement agreements, civil rights enforcement would be seriously undermined. Given this concern, I hope to offer an amendment addressing at least one shortcoming of the bill. And finally, 469 will inevitably generate more litigation that will result in millions of dollars of additional transactional costs, all of which will be borne, of course, as usual, by the taxpayer. For example, the nonpartisan Congressional Budget Office, in its analysis of the bill's predecessor from the last Congress, concluded the measure would impose millions of dollars in additional costs, most of which would be incurred because litigation involving consent decrees and settlement agreements would probably take longer under the bill, and agencies would face additional administrative requirements. So for these reasons and more, I urge the Judiciary Committee to accordingly oppose H.R. 469. I thank the chairman and yield back any time remaining.
Thank you, Mr. Conyers. It's now my pleasure to recognize the sponsor of the bill, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. Thanks for yielding, and I appreciate you holding this markup today. I've introduced the Sunshine for Regulatory Decrees and Settlement Act because too often we have seen pro-regulatory plaintiffs sue sympathetic agencies to enact regulations in the dark, absent public input, in order to subvert participation by affected parties, minimize public participation, and bind agencies' discretion. This is not new. We have passed this in the preceding Congresses, and it's still the same issues that we're dealing with. In short, sue and settle agreements use litigation to bind agencies to regulations without the participation envisioned in the APA. I'm encouraged by the Trump administration's progress to restore the policy set out in the original Meese memo, and I'm excited to work with them on this legislation so that we can permanently put an end to sue and settle agreements as they currently are being used. We need to ensure that special interests are never again able to use consent decrees to exclude public from meaningful participation in the regulatory process. That's because these settlements have tangible effects. They affect industries and jobs and families across the country, from Northeast Georgia to the Pacific Ocean. The hardworking men and women in Georgia and across the country are trying to make an honest living, and I have a problem with special interests threatening that livelihood. The potential for abuse and lack of transparency in the system is why I believe so strongly that there's a need for this legislation. My bill will restore transparency and increase public participation and input. H.R. 469 addresses weaknesses in the current system while preserving, notice this, Mr. Chairman, preserving consent decrees is an important mechanism for settling legal disputes. This does not end consent decrees. The ability for citizens to hold government accountable is an important part of administrative law, but it must be properly carried out and appropriately carried out with transparency and full public participation. This legislation restores the balance and the intent of the APA and ensures that those who wish to subvert the rulemaking requirements in current law are unable to do so. This is simply a good government legislation that restores the ability of the American people, not the special interests, to weigh in on the rules that affect the livelihoods and businesses. And Mr. Chairman, before I yield back, it has been noted that there are many organizations who are opposed to this bill, it would be also proper to note that the organizations who are opposed to this bill are also the ones who seek to have the least transparency in this process because they have benefited over time from a lack of transparency in this process. So it is not surprising that many of these would actually be opposed to that. And with that, Mr. Chairman, I appreciate the time and I yield back.
Chair, thanks, gentlemen. The Chair understands the gentleman from Rhode Island, Mr. Cicilline, who is the ranking member on the subcommittee, wish to be recognized, and I'm happy to do so. If the gentleman would yield to me, though, briefly, I'll make sure you have your full time.
Of course.
I thank the gentleman for yielding. I want to say to the gentleman from Maryland, Mr. Raskin, that I've come to learn that you also had an amendment you wish to offer. And I know from earlier discussions and from discussions going on that there's at least one amendment on our side of the aisle. So the offer that I have extended to the gentleman from Rhode Island and the gentleman from Washington, I also extend to the gentleman from Maryland and to the gentleman from Idaho. We'll continue to work with you. I can't guarantee your amendment can be incorporated, but if it or a modification of thereof can be, we'll work with you to try to accommodate your interest in that. And now I thank the gentleman from Rhode Island for yielding to me.
Thank you, Mr. Chairman. H.R. 469, the Sunshine for Regulations and Regulatory Decrees and Settlements Act of 2017, is an unwarranted and costly measure that will undermine Congress's constitutional powers. When passing laws, Congress routinely establishes mandatory deadlines for agency action. These statutory deadlines serve several purposes. They establish Congress's priorities for agency action, attempt to reduce undue delay in agencies' compliance with the law, and communicate the importance of a legal requirement to the public. But because agency resources are limited, there's widespread noncompliance with statutory deadlines, as the Administrative Conference of the United States has long observed. Accordingly, a plaintiff with standing may file a lawsuit to determine a schedule for an agency to complete an action required by Congress, often referred to as a deadline suit. As the Nonpartisan Government Accountability Office reported earlier this year, most deadline suits are resolved through a negotiated settlement agreement because in the majority of them it is undisputed that a statutory deadline was missed. There was no legal defense to the lawsuit. But proponents of H.R. 469 assert that these settlements, quote, undercut applicable administrative law and, quote, short-circuit review of new regulations. This premise is based on a report by the Chamber of Commerce that so-called sue and settle process is increasingly being used as a technique to shape agencies' regulatory agendas. This concern, however, is unsupported by any independent evidence and has been debunked by the Government Accountability Office. In 2 reports on deadline lawsuits, the GAO has found that, and I quote, the settlement agreements did not affect the substantive basis or procedural rulemaking requirements, end quote, of the agencies it studied. In its December 2014 report on deadline lawsuits involving the Environmental Protection Agency, the GAO determined that none of the settlements of deadline suits finalized under the Obama administration, quote, included terms that finalized the substantive outcome of a rule, end quote. The GAO underscored this point in the title of its report, Impact of Deadline Suits on EPA's Rulemaking is Limited. In its February 2017 report on deadline lawsuits involving the Endangered Species Act, the GAO found that the settlement agreements did not affect the substantive basis or procedural rulemaking requirements the agencies were to follow in completing the actions, such as providing opportunities for public notice and comment on proposed listing rules, end quote. Leading experts have also debunked the Chamber's sue and settle narrative. John Cruden, a senior career official with the Justice Department for more than 2 decades during 2 Republican and 2 Democratic administrations, testified in a substantially identical bill that he was, quote, not aware of any instance of a settlement that could remotely be described as collusive, but that the Justice Department vigorously represented the federal agency, defending the agency's legal position and obtaining in any settlement the best possible terms that were consistent with the controlling law, end quote. Other administrative law experts, such as Robert Weissman, the president of Public Citizen, have similarly testified that sue and settle allegations are patently false. This bill is also unnecessary because current law and agency practice already restrict the use of settlement policy to shape regulatory priorities. During its exhaustive review of deadline litigation, the GAO found that the Justice Department is guided by the Meese memo of 1986 when litigating deadline suits. This policy, as the GAO noted earlier this year, limits the settlement of a deadline suit to, and I quote, only include a commitment to perform a mandatory action by an agreed-upon schedule and would not otherwise predetermine or prescribe a specific substantive outcome for the actions to be completed by the agencies, end quote. The Meese memo was codified in 1991 in the Code of Federal Regulations and applies to settlement policy today. The The Meese policy primarily restricts agencies from using settlement policy to contravene the law or congressional intent. As the majority noted in its report on a substantially identical version of this bill considered last Congress, this policy is grounded in separation of powers concerns. There is no evidence that agencies do not follow this policy, and the majority's witnesses at prior hearings on this proposal have been unable to provide examples of settlements that violate the Meese policy. Finally, H.R. 469 is wasteful and undermines Congress's Article I powers. Congress, not agencies, establish regulatory priorities through statutes. Agencies do not have discretion to pick and choose regulatory priorities where Congress has expressly instructed that certain actions be undertaken by a specific date. By imposing a series of onerous procedures that will constrain the use of settlements to resolve a federal agency's noncompliance with the law, H.R. 469 erodes the constitutional function of the legislative branch. The bill is also costly. The Congressional Budget Office has previously noted that this measure will greatly lengthen the settlement process, cost millions of dollars, and strain the Treasury's judgment fund, and lead to an increase in the amount of reimbursable attorney's fees. In closing, I strongly oppose this measure for all of those reasons and yield back the balance of my time.
Are there any amendments to H.R. 469? For purpose of the gentleman from Texas, for purpose of the gentleman from Michigan, seek recognition.
Mr. Chairman, I have an amendment at the desk and ask that it be reported.
The clerk will report the amendment.
Amendment to H.R. 469 offered by Mr. Conyers. Page 3, line 10.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My colleagues, my amendment would exempt from H.R. 469 consent decrees and settlements agreements that prevent or are intended to prevent discrimination based on race, religion, national origin, or any other protected category. Given the often systemic nature of discriminatory conduct, settlement agreements and consent decrees offer an invaluable means to provide for general relief for non-identifiable victims and to prevent future discriminatory acts. In particular, settlement agreements have been instrumental in enforcing various civil rights statutes in a wide variety of cases, ranging from those involving voting rights to reform of mental health institutions to law enforcement misconduct and others. Recent examples include the Justice Department's use of court-enforceable consent decrees addressing unconstitutional police pattern or practice activities. In 2003, for instance, the city of Detroit entered into a consent decree with the Justice Department concerning the use of force and arrest practices by the city's police department. As a result of this decree, the police department implemented vastly improved practices that have substantially reduced the incidence of fatalities caused by law enforcement activities, a goal that the chairman and I very much endorse. As reported by the department's Civil Rights Division earlier this year, these agreements emphasize institutional reforms such as improving systems for supervising officers and holding them accountable for misconduct, and ensuring officers have the policy guidance, training, equipment, and other resources necessary for constitutional and effective policing. H.R. 469 would make the use of such remedies exceedingly difficult by subjecting them to numerous procedural and potentially meritless court challenges. I am particularly concerned that the bill's broad and ill-defined requirements would effectively deter civil enforcement agencies from providing general relief in discrimination cases, discourage courts from enforcing these settlements, and invite costly and needless litigation concerning these provisions. Accordingly, My amendment would simply exclude from the burdensome requirements of the bill settlement agreements and consent decrees intended to remediate generalized harms in civil rights cases. I urge my colleagues to give careful consideration to this important amendment. I thank the chairman and yield back any time remaining.
For purpose, the gentleman from Georgia seek recognition.
Mr. Chairman, I oppose the amendment.
Gentleman's recognized for 5 minutes.
Thank you. Although I have, great respect for the ranking member, I would have to oppose this amendment. This amendment seeks less transparency, public participation, judicial review for consent decrees and settlement agreements for regulations that allegedly will help protect civil rights. With all due respect, I believe that this has matters backwards. More transparency, public input, judicial scrutiny will not only help produce regulations that better protect these rights, but it'll also involve more participation by those that are being affected by this, from regulated entities to state, local, tribal entities that may be affected and enforce this legislation, but also may bar buy-in from these groups. So with those things in mind, this will help regulations be better, more promptly implemented, and with that, I would encourage my colleagues to oppose the amendment. And that, I yield back.
Purpose, the gentleman from Rhode Island seek recognition.
Seek time in support of the amendment.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in strong support of Mr. Conyers' amendment and thank him for introducing this amendment. As the members of this committee know, the civil rights laws reflect our deeply held and important founding values of equality, and the treatment under the law should be equal among all of our citizens. And in fact, the very well-established principle that no one should be treated adversely solely on account of their race, sex, religion, national origin, age, disability, or sexual orientation. And consent decrees in particular have been very important in enforcing various civil rights statutes in a wide variety of cases, ranging from those involving voting rights to the reform of mental health institutions to law enforcement misconduct, and the list goes on and on. Really and truly, civil rights enforcements are really at the heart of preserving the very important founding values of our country. And this legislation, without Mr. Conyers' amendment, would make it substantially more difficult for agencies to enter into consent decrees or settlement agreements regarding civil rights enforcement, and would effectively undermine Congress's statutory mandates to agencies concerning very important issues of civil rights. So I rise in strong support of Mr. Conyers' amendment. I think this is an important area that should have particular consideration by the Judiciary Committee when one considers the very special role that civil rights laws have played in the development of our country. And so I urge all of my colleagues to support the Conyers amendment, and I yield back.
Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it, and the amendment is not agreed to.
Record vote.
A record vote is requested, and
Thank
the
you.
clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Rutherford? Mr. Rutherford votes no. Ms. Handel? Ms. Handel votes no. Mr. Conyers? Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnston of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Mr. Iapol? Mr. Iapol votes aye. Mr. Snyder? Mr. Snyder votes aye.
The gentleman from Texas.
Mr. Farenthold votes no.
The gentleman from California.
Mr. Issa votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 6 members voted aye, 14 members voted no.
And the amendment is not agreed to. Are there further amendments? What purpose the gentleman from Texas seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 469 offered by Ms. Jackson Lee. Page 3, line 10.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
I thank the chairman very much and the ranking member. And in just a moment, Mr. Chairman, I appreciate the collegiate work of H.R. 2851, the Stop the Importation trafficking of Synthetic Analogs Act of 2017. Not knowing how the bill reached the floor, I want to be registered as a no vote on that bill, 2851, which was voice voted. I want to be registered as a no vote. Let me, I ask unanimous consent. Mr. Chairman.
What purpose does the gentlewoman seek unanimous consent?
To register,
It's not possible to do that at this time,
but I will place it into the record. Thank you.
Your voice has been heard in the record.
Thank you so very much, Mr. Chairman. Let me proceed with the amendment. The Jackson Lee amendment creates an exemption for consent decrees and settlement agreements addressing harm done to individuals who were exposed to toxic substances, hazardous waste, and other environmental injustices within the scope of Executive Order 12898, signed by President Clinton, February 11th, 1994. Let me say that Houston has not been a stranger to Superfund sites. We had 11 as of 2007. We still have 2 remaining. One is a 21-acre site located in an industrial, commercial, and residential section of Houston. The first site is a former wood treating plant that contaminated soil and groundwater with volatile organic compounds, PAH, and metal salts such as arsenic, chromium, copper, lead, and zinc. I walked amongst a Superfund site and looked at the backyards of our neighbors in the 18th Congressional District. And so I realized the importance of recognizing the danger of impact of not being regulated or not being protected by the EPA. The EPA is working to assure the safety of those close to the Superfund sites. We as legislators must assure that these communities remain safe and are not disproportionately affected because of the color of their skin or the money in their wallets. So the Jackson Lee Amendment is a healthy exemption to this particular legislation, and it responds to what is perceived as favoring industry interests at taxpayer expense and promotes regulatory uncertainty. The Jackson Lee Amendment would protect people such as Teresa Deonda, her family, and her neighbors, all who were victims of a large-scale pesticide drift in her hometown of Early Mart, California. While she was running errands, a toxic pesticide drifted into town from the agricultural fields about a quarter of a mile from her home. She came home to find the sheriff standing at the front gate and her husband telling her they needed to leave the area. They bungled up in the car and left town. Meanwhile, neighbors and other people were from the hometown were undergoing a botched decontamination process organized by the government. The sickest people who were vomiting, experiencing other acute symptoms of pesticide poisoning, were taken to local schools, made to take off their clothes with little privacy and sprayed down with fire hoses in the cold night. The Jackson Lee Amendment would not only protect people like Teresa in her community, but also protect low-income groups who are disproportionately, as I said, impacted by these harmful substances. By the way, the Superfund that I walked through, or the contamination, was in fact in a low-income senior citizen populated neighborhood. High-profile cases such as the Flint water crisis highlight the importance of race and socioeconomic plays in environmental justice. Tens of thousands of people were drinking exposed water exposed to toxic levels of lead And we know the story of Flint, and we know the devastation on people who were of many backgrounds, not only African Americans, but white individuals, residents of Flint, were involved, but they were not rich. And so this is the importance of this amendment. It is a simple, straightforward provision that would create an exception for consent decrees and settlement agreements in environmental justice cases that often disproportionately harm the marginalized. I ask my colleagues to support the Jackson Lee amendment. I yield back.
Mr. Chairman.
For purpose, the gentleman from Georgia seek recognition.
I oppose the amendment, Mr. Chairman.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and I appreciate the gentlelady from Texas. She and I have worked on many things together, from criminal justice to other, and her outlook and perspective for protecting those in need has never been questioned. I do not question here, but I do believe that this amendment is basically a backdoor that would continue to hide these consent decrees and settlement agreements about toxic substances and hazardous waste regulations from the bill's protection. And that's just something I could not support. I understand that my colleague seeks to protect individuals in poor and minority communities that may benefit from new rules, but who can say that the backroom deals negotiated by special interest groups, often from outside the communities, will be the ones that work in those communities' best interest? The Regulatory Reform Subcommittee has received multiple times testimony that new environmental regulations can impose regressive negative cost impacts on poor and vulnerable populations. That can happen notwithstanding the best intentions of an outside group. These deals advance only one special interest group's views, threatening all Americans who are concerned about toxic substances and hazardous waste. This bill actually, again, I repeat it again, does not do away with consent decrees. It just simply opens up transparencies and scrutiny to assure public interest is best protected in all these areas. With that, Mr. Chairman, I would encourage all my colleagues to oppose this amendment.
Mr. Chairman.
Yield back. For purpose, the gentleman from Michigan seek recognition.
I rise in strong support of the
Gentleman is
Jackson
recognized
Lee
for 5
amendment.
minutes.
Thank you. Members of the committee, this amendment would exempt from the bill any consent decree or settlement agreement regarding environmental justice in low-income or minority communities as defined by Executive Order 12898. Based on the legislative history of this bill, it is clear that its main target is simply getting the Environmental Protection Agency, EPA, and environmental groups. As I've often repeated, many of those who attack regulations forget that the reason that they can take for granted clean air or drinkable water and non-toxic soil is because of strong environmental regulation. The gentlelady from Texas mentioned Flint, Michigan, and believe me, having been there at least 3 or maybe 4 times, I can tell you this amendment was be very, very helpful in this part of Michigan. These environmental hazards are particularly acute in low-income and minority communities. I don't think that's by accident. President Clinton recognized the particularly high risk of environmental hazards in low-income and minority communities when he issued Executive Order 12898 back in 1994, which directed federal agencies to take certain steps to address environmental justice concern. The United States Commission on Civil Rights 2002 study of and report on the implementation of Executive Order 12898 found that 4 federal agencies, including EPA, have failed to incorporate environmental justice into their core concerns and have not established accountability and performance outcomes for programs and activities, and lack a commitment to environmental justice issues from agency leadership. Yet when federal agencies acknowledge through a consent decree or settlement that they've unlawfully denied or unreasonably delayed regulations needed to prevent sickness and death caused by discriminatory treatment, this bill would make that agency jump through more legal hoops before it can finally do its job. The bill requires already negotiated settlements to go to mediation if a third party, like a company that is causing pollution, intervenes. And for those reasons, I support the amendment and urge my colleagues to do the same. Thank you.
Mr. Chairman,
For purpose, the gentleman from Washington seek recognition.
move to strike the last word.
Gentleman was recognized for 5 minutes.
Thank you, Mr. Chairman. I rise today in strong support of Ms. Jackson-Lee's amendment, which would ensure that consent decrees or settlements may continue in cases related to reducing illness or death from exposure to toxic substances. And we've heard from several of my colleagues how those situations particularly disproportionately affect low-income communities and communities of color. Certainly in Washington State, my home state and my home district, we have a deep understanding that our livelihoods depend on preserving our environment and preventing the spread of toxic substances, and those substances and processes that actually damage our human health. This amendment simply ensures that when the government misses deadlines to enforce congressional federal agency actions around environmental law, people may continue to sue to enforce these deadlines. And that is critical because there are no legal defenses for missing statutory deadlines. Mr. Chairman, I'd like to ask for unanimous consent to introduce into the record a letter from 29 organizations, including a number of environmental justice organizations.
Without objection, they will be made a part of the record.
Thank you, Mr. Chairman. The letter states that, and this is a quote, "The consent decrees and settlement agreements at issue do not determine the substance of agency rules. Rather, such agreements simply seek to enforce mandatory statutory and procedural duties, such as deadlines enacted by Congress." And so, with all due respect to my colleague from Georgia, Mr. Collins, his statement that this is somehow a backdoor to extending things that aren't appropriate, that is simply not true. And this is actually supported by 2 GAO reports, which I'd also like to ask for unanimous consent to introduce into the record.
Without objection, they will be made a part of the record.
Thank you. The 2014 GAO report entitled "Environmental Litigation, Impact of Deadline Suits on EPA's Rulemaking is Limited," that's the title of the report, states, and this is a quote, "The effects of settlements in deadline suits on EPA's rulemaking priorities is limited." Separately, in the February 2017 GAO report entitled "Environmental Litigation, Information on Endangered Species Act Deadline Suits," the GAO found, and this is again a quote, "The majority of deadline suits filed during fiscal years 2005 through 2015 were resolved through negotiated settlement agreements that established schedules for the agencies to complete the actions involved in the suits. Agency officials said that most deadline suits are resolved through settlement because it is undisputed that a statutory deadline was missed. Other than setting schedules for completing Section 4 actions, the settlement agreements did not affect the substantive basis or procedural rulemaking requirements that the agencies were to follow in completing these actions, such as providing opportunities for public notice and comment on proposing listing rules." Mr. Chairman, it's clear that this is just another bill that's based on false sue and settle myth, and I really hope that my colleagues on both sides will vote for this common sense amendment that makes this bill just a bit better, and I thank my colleague from Texas for introducing this important amendment. I yield back.
The question occurs on...
Chairman?
Who seeks recognition? The gentleman from Iowa is recognized.
I just want to make a quick statement here that I support this legislation. I think it's practical and it's brought forward with real-life experience. And as a gentleman from Georgia, I'd be happy to yield to the gentleman from Georgia.
I thank you for yielding. And just a very quick point, I think one of the issues that the GAO report actually is pointing out is the problem with the suit and the consent decree being filed on the same day. And I think these are the issues that we're adjusting priorities. And I'm not going to say that there may not be a desire or a want to from the agency. I think what we're filing out here is just a transparency issue where those who are involved are not being able to be a part. And that's all this is. It does not do away with consent decrees. It does not, which has been talked about before, simply adds transparency. And I appreciate the gentleman yielding. I yield back.
Reclaim my time, and I return my time to the chairman and urge adoption of this legislation.
For Does the gentleman from Maryland seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized for 5 minutes.
Thank you very much. First, I want to start by thanking the chairman very much for his kindness and flexibility in talking to us about amendments that got lost at the last moment in the parliamentary confusion of H.R. 2851. I do have an amendment which I consider very important as the representative from NIH, having spoken to a number of researchers who are in Schedule 2, and there are 5,000 of those who feel that their ability to pursue both treatment and research into the nature of addiction within the opioid crisis will be affected negatively by this legislation unless we have this amendment. So I really thank you very much for your willingness to hear about this. And I look
Would the
forward to-
gentleman yield?
Yes, by all means.
I would be interested in hearing more about that, so we'll be happy to consider that, and we'll have discussions moving forward.
Thank you so much, Mr. Chairman. I look forward to it. And then I just wanted to say a word on behalf of Ms. Jackson-Lee's amendment to 469. You know, the problem of toxic contamination in our communities is a severe one all over the country, and we know that too often environmental pollution and contamination have followed lines of race and class, and we simply want to make sure that this legislation, if it passes, H.R. 469, does not undermine efforts that are already underway to deal with the problem of environmental racism and toxic contamination of the most vulnerable and exploited communities in the country. So I will be supporting Ms. Jackson-Lee's amendment, and with that, I yield back, Mr. Chairman.
Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Any in the chair, the noes have
Roll
it.
call, Mr. Chairman.
Court vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Rutherford? Mr. Rutherford votes no. Ms. Handel? Ms. Handel votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Ms. Jackson-Lee?
Aye.
Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Gentleman from Texas, Mr. Farenthold.
Mr. Farenthold votes no.
Gentleman from Florida, Mr. Gates.
Mr. Gates votes no.
Gentleman from Pennsylvania.
Mr. Marino votes no.
Gentleman from New York.
Aye.
Mr. Nadler votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 7 members voted aye, 15 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 469 for the gentleman from Rhode Island to seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 469 offered by Mr. Cicilline. Page 3, line 10, strike and insert other than an accepted consent decree or settlement agreement, page 3, line 2, strike the period and insert and, page 3, insert after line 21 the following.
Without objection, the amendment is considered as read, and the gentleman is recognized on his amendment.
Thank you, Mr. Chairman. My amendment would exempt from H.R. 469 any settlement or consent decree that relates to a deadline established by Congress to address the misuse of prescription painkillers established by statute, such as under the Comprehensive Addiction and Recovery Act of 2016. Opioid addiction is a public health crisis that is devastating our local communities. Rhode Island, my home state, has one of the nation's highest rates of death due to drug use, addiction, and overdose related to opiates. But Rhode Island is not alone in the fight to save lives through policies designed to ensure the treatment and prevention of opioid abuse. Nationwide, the Center for Disease Control reports that opioids contributed to the deaths of 28,647 Americans in 2014, while new research demonstrates that the amount of opioids prescribed remains approximately 3 times as high as in 1999. In response to this concern, Congress enacted the Comprehensive Addiction and Recovery Act of 2016, the first major federal law enacted to address the opioid epidemic that was passed with overwhelming bipartisan support. Among its requirements to improve the treatment and recovery of opioid addiction, this law requires that the Department of Health and Human Services implement regulations within 18 months of the bill's enactment to provide for best practices for the treatment of opioid-dependent patients based on consultation with experts in opioid use disorder research and treatment. But should the agency miss this deadline, any citizen with standing could file a deadline lawsuit to ensure that the agency implements this requirement on an agreed-upon schedule. This is only one example of a statutory deadline established by Congress to ensure swift and effective agency action to respond to a public health crisis. H.R. 469, however, would paralyze this process by requiring notice and comment prior to the settlement of deadline suits and allowing practically unlimited intervention in these cases. Mr. Chairman, we all agree that the federal government must do more to combat opioid addiction and assist medical providers in providing the best treatment and recovery options for patients. I urge my colleagues to support my amendment to ensure that H.R. 469 does not impede this important goal. And I would ask unanimous consent, Mr. Chairman, to insert in the record a letter from the Coalition for Sensible Safeguards in opposition to the bill, which says in part, the Sunshine for Regulatory Decrees and Settlement Acts is an assault on the public protections and safeguards required by the laws Congress passed to protect the health, safety, and welfare of all Americans. H.R. 469 would waste the limited time and resources of agencies, courts, and the American public, and they expressed their strong opposition. And with that, Mr. Chairman, I yield back the balance of my time.
Gentleman asking unanimous consent that that letter be made a part of the record. Without objection, it will be made a part of the record. For the purpose of the gentleman from Georgia seek recognition.
Mr. Chairman, oppose the amendment.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Look, I agree with my friend from Rhode Island. The opioid crisis is devastating. It's severe. It's mine in his state as much as it is in my part of the world as well. And we've already appropriated funds to address this. He made a great deal of mention about the Comprehensive Addiction and Recovery Act of 2016. And I think one of the interesting things that was pointed out there was the simple fact that it required the department to actually have consultation and find best practices. It actually opened up the process. I think this is exactly what we're trying to do here, is have a process that works, again, not getting rid of consent decrees, not removing that part of the judicial review, but also having the fact that what we're trying to do is not seek to have less transparency, but more, not less public participation, but more. And I think this is just another issue that would be best addressed as it is currently having. Locals know best how to address this issue. This amendment would, frankly, would exempt that and reduce the need input accordingly. I would urge my colleagues to oppose this amendment. I appreciate the gentleman bringing this is a big issue that we're continuing to address in Congress. I just do not believe it's right here and would oppose the amendment and yield back.
Mr.
Gentleman
Chairman,
yields back. The ranking member is recognized.
I support this amendment and ask unanimous consent to proceed for the regular amount of time.
The gentleman is recognized for 5 minutes.
Thank you. Members, exception for consent decrees or settlement agreements relating to statutory deadlines to address the misuse of prescription painkillers is exceedingly important. I support the gentleman from Rhode Island's amendment, which is designed to ensure that H.R. 469 doesn't prevent the enforcement of a statutory deadline established by Congress to address the opioid epidemic crisis. These issues must be separated. We're in the midst of a major public health crisis caused by prescription and opioid abuse. Drug overdoses are now the leading cause of death in our nation. This crisis affects Americans of all ages, races, income levels in our cities, suburbs, and rural areas across America. In 2016, last year, Congress enacted the Comprehensive Addiction and Recovery Act, the first comprehensive effort to address this crisis. Among its requirements, this law establishes statutory deadlines for the Department of Health and Human Services regarding best practices for the treatment of opioid abuse. But as President Obama noted when signing this bill, the Addiction and Recovery Act, into law, he said that it only includes modest steps to address the opioid epidemic, and he was right. Congress, we in judiciary, can and should do more to support our local communities and American families who are in desperate need of assistance. H.R. 469, however, would encumber these efforts for any law relating to opioid treatment, addiction, and recovery. The bill opens the floodgates to industry challenges that would delay the resolution of pending litigation by changing the standard for third-party intervention in underlying litigation. Section 3B of the bill requires courts to presume, subject to rebuttal, that almost any private third party be allowed to intervene in litigation between a public interest group and a federal agency concerning a regulatory action that would require that such third party be permitted to participate in settlement negotiation between two litigants. Effectively, this shift in the burden of proof makes it much easier for any entity that is not already a party to the case to intervene in a case involving a consent decree or settlement agreement that seeks to compel agency action. By greatly expanding opportunities for industry to slow down this process, H.R. 469 effectively makes it more expensive for agencies to do what Congress has mandated it to do, while imposing greater costs and strains on the judicial system, and in the process waste countless taxpayers' dollars in costly procedural delays. H.R. 469 also imports a burdensome and time-consuming notice and comment process into litigation involving these suits. These provisions are designed to prevent the timely enforcement of statutory deadlines, such as those designed to ensure the safe and effective treatment of opioid abuse patients. Accordingly, I urge all the members of the committee to support this important this important amendment. I thank the chairman.
Thank you very much. Gentleman's time has expired.
Move to strike the last one.
Gentleman from Maryland is recognized.
Mr. Chairman, thank you so much. Having spent some time in the more rural parts of my district over the weekend and talking to people affected by the opioid crisis, I want to rise in favor of Mr. Cicilline's amendment. There is more than one person every day who dies in my state, in Maryland, from the opioid crisis. I dare say that's probably the case in the states of everybody on this committee, and it might be as many as 2, 3, 4, 5 people who are dying every single day. So Mr. Cicilline's amendment simply makes clear that a covered consent decree or settlement agreement pertaining to a deadline established by Congress through the enactment of a federal statute to address the misuse of prescription painkillers will not be blocked by virtue of passage of this legislation. I think given what Congress did last year with comprehensive legislation to try to deal with this, it would make no sense for us to undermine our own efforts to deal with the opioid crisis. We want to make sure that the federal agencies have every possible power, every possible tool in the toolkit in order to go forward to address effectively the opioid crisis that is engulfing our country. So I rise in very strong favor of Mr. Cicilline's amendment, and I yield back to you, Mr. Chairman.
Thank you. Gentleman yields back. Does any other member seek recognition? If not, the question is on the amendment. Those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it. The
Mr.
amendment is
Chairman, I
not agreed
request
to.
a recorded vote.
Clerk will call the roll.
Mr. Goodlatte?
No. Well, I'm sure he'll be a no. I was just...
Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Isa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Rutherford? Mr. Rutherford votes no. Ms. Handel? Ms. Handel votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Mr. Jayapal? Mr. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
The question, gentleman from Virginia?
Mr. Goodlatte votes no.
Gentleman from Texas?
Mr. Poe votes no.
Gentlelady from California?
Ms. Lofgren votes aye.
Are there any other members who seek recognition? If not, the clerk will report.
Mr. Chairman, 8 members voted aye, 15 members voted no.
And the amendment is not agreed to.
Record vote.
Are there any other members who seek to make an amendment to the bill? If not, a recorded quorum being present, the question is on the motion to report the bill, H.R. 469, favorably to the House. Those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill
Recorded
is ordered.
vote.
Okay, the clerk will call the record.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Isa? Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Rutherford? Ms. Handel? Ms. Handel votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Snyder? Mr. Snyder votes no.
Gentleman from Virginia?
Mr. Goodlatte votes aye.
Gentleman from Texas?
Mr. Poe votes yes.
The gentleman from Texas?
Mr. Farenthold votes yes.
Gentleman from Florida?
Mr. Rutherford votes yes.
Are there any other members who wish to vote? If not, clerk will report.
Mr. Chairman, 15 members voted aye, 8 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House, and members will have 2 days to submit views. That's it, right? Oh, I'll do it. Okay. All right, we want to thank all members for their participation this morning, and if there's no further business to come before the committee, we're adjourned. Thank you.
Thank you.
Okay, thank you, John. Hope I didn't screw up too bad there. Other than, good lad, so.